Good morning, Mr. McCann.
Good morning, sir.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Complainant and defendant are in a former dating relationship. On 6/29, officers were dispatched to a disturbance at a business in Harris County, Texas. Complainant entered the business, and when she exited and walked back to her truck, she observed the defendant there. Complainant believed defendant had followed her. Complainant said the defendant was intoxicated and started to insult her. Complainant stated defendant struck her on the left side of her face with a closed fist as she sat down inside of her truck, causing pain. Complainant stated she went after defendant as he entered his truck and grabbed his shirt. Complainant stated she was momentarily dragged as she held onto the defendant's vehicle.
So it was a hit to the face, you see?
Yes, Judge. We have not been able to arrest her yet. I will let you know that I was reading through the offense report. I don't know if this was mentioned to intake, but in the offense report, it does look like she was 4 months pregnant at the time, and the defendant was aware, so this baby refiled.
Wolf 4 months pregnant during the alleged assault.
Hold up, she was 4 months pregnant during the alleged assault. That's not just a detail, it's a legal landmine in Texas. Assaulting a pregnant person can instantly turn a misdemeanor into a felony. What's your take? Is that fair? Or does it depend on the intent and injury? Let us know in the comments.
That's a legal game changer. In Texas, assaulting a pregnant person can raise the charge from a misdemeanor to a felony. Even if the injury was minor, the law takes unborn child protection very seriously. What do you think? Should pregnancy always escalate charges like this?
This is a felony, I'm not sure yet, but so we're not right now.
Mr. Tejada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you're using, I will revoke your bond, put you in jail. I'm going to do everything in my power to protect my public at all costs. Do you understand?
Yes, sir.
You will not have any contact with the complaining witness in this case. Do not be in possession of weapons. And I'm now entering what's called a magistrate order for emergency protection. This is a court order that identifies Ms. Lopez Leiva as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass.
Listen to that, the judge calls violating a protective order the capital murder of misdemeanors. That's not just tough talk, it reflects how seriously courts take domestic violence and stalking laws. This isn't just about punishment, it's about prevention.
Use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Sir.
If you violate this court order, the state can and will probably file a violation of protective order, and that is the capital murder of misdemeanors. It is one of the worst cases you can pick up, a violation of protective order. Do you understand?
Sir.
You pick up one of those, violate conditions, I can have a hearing to hold you at no bond. Zero bond. And I'll do it in a heartbeat to protect my county. Any prior assaults against this person or?
No, Judge, this looks like it's the first one.
Okay. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Parr. If he tells me he can't get a hold of you because you've gone AWOL, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for your arrest. You get no more PR bonds. Do you understand?
Yes, sir.
You will be randomly called upon to go take drug and alcohol tests. If you fail to go, then likewise a warrant for your arrest will be issued. I'll have you go sign a reset with Victoria. You'll sign the order for protection here. You'll get with police for your bond conditions, and after that, you're free to go.
Just,
Oh, is there no bond set?
well, no,
Oh, there is.
Judge, with regards to the bond conditions, I was wondering if we could, amend those or have them reflect the no threat and harassing communication, instead of no contact.
They haven't been able to reach her.
They haven't, but the DA hasn't, but then she has spoken with her back. And she had spoken to the back and told her that she would want to proceed with the case. She would,
I don't know. I mean, if she's 4 months pregnant,
no, she's already had the child. They already have a child now. That's the only reason why I say it now.
Yeah, this did happen back in June.
They do have a,
If,
let's do this. I want to know, I mean, if that VAC was done, that VAC was done in 2024. I don't know anything recent. So until I know what she wants now, then, you know.
That moment right there, no means no, is more than a cliche. It's the judge drawing a hard legal and moral line. Regardless of past relationships or shared parenting, the court is putting boundaries front and center. Should past connections ever soften these rulings, or is strict protection the only way?
And if you could, facilitate, perhaps give a phone number, maybe that's something that can happen now. I don't know, but I like to follow the wishes of the complaining witness, and I don't know what her wishes are. If she doesn't want contact with you, then I'm gonna worry. If she does, then we can revisit that at that time. But understand, for this instant, no means no. It doesn't mean maybe. It doesn't mean I gotta go get my kid. It doesn't mean someone has to go take the SAT. No means no. Do you understand?
Sir.
Okay. All right. Thanks, guys. Good morning, Mr. DePaz. So you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Oh, thank you.
On March 10th, 2025, at approximately 12:18 p.m., a school resource officer responded to a security officer needing assistance in LaPorte High School.
Whoa, double jaw fractures and weeks of recovery, and it still might not meet the legal standard for serious bodily injury. This shows how tricky legal definitions can get. The injury's brutal, but unless it's permanent disfigurement, the law might call it just an assault.
Upon arrival, the defendant was placed in the security resources office after a physical altercation. The defendant stated he was upset with the complainant because the complainant had mistreated his sister in the past. The defendant confronted the complainant and struck the complainant with a closed fist on his face. The defendant was observed on school CCTV walking up to the complainant and punching him with a closed fist, and shortly after, the complainant fell to the ground. The complainant did not show signs of confrontation towards the defendant. The complainant was observed with multiple lacerations on his lower lip and a missing tooth from being struck in the face. The complainant was also observed with a swollen jaw and bleeding from his mouth, and the complainant felt pain. I have spoken to the family of the complainant. He's had to have his jaw wired shut. His jaw was broken on both sides of his face.
Serious bodily injury?
I don't believe that would rise to the level of serious bodily injury because it's not permanent disfigurement, because he will heal eventually, but it will take 6 to 9 weeks.
Mr. Topaz, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're smoking weed, if I find that you're using alcohol, I will put you in jail. You will get your degree with me. Do you understand? You are now not to go back to LaPorte High School. I'm ordering you not to go back. I don't want this person to live in fear, so you're not to go back there. Do you understand?
Yes, sir.
If I find that you become a danger to my community, I only have one place for you.
Yes, sir.
You're not to be in possession of weapons as well. You were what, 17?
Yes, sir.
Okay, I will provide you a lawyer today. I'm sending you for a drug test. I want to know what, if anything, is going to be in your system. You're to take a test and you're to come back, and then I'll have to speak to a lawyer.
Yes, sir.
If you don't go take the test, if you don't come back, I will issue a warrant for your arrest.
Yes, sir.
I know it's your problem. You got out of jail because we gave you a free bond. You're not going to get another one if you're a danger to my community.
Yes,
You
sir.
understand?
Not causing.
Okay.
And Judge, did you say no contact with the complaining witness?
Correct.
Okay.
But don't worry, don't file anything because I'm going to have him supervised. All right, so just reach out to the MAC form, please, and I'm going to send him for a test right now.
Okay. Well,
Rand. How are you? Great. How are you? Judge looks very festive today.
I know you're ready to go.
So this is an FSGI, am I right?
Yes, sir. Hola, yo te voy a interpretar, ¿ok?
Good morning, Ms. Reyes.
Sam Diaz, señor Reyes.
Good morning.
Ms. Reyes, you're charged with failure to stop and give information. Essentially, leaving the scene of an accident without exchanging information.
Era de un accidente sin intercambiar la información que necesitabas hacer.
You are facing up to 180 days in jail
180 días en la cárcel por
and or a $2,000
una
fine.
multa que no sobrepase $2,000.
We are going to do probable cause.
Soldados,
You have the right to remain silent. Anything you say can or will be used against you.
contra usted.
I insist she stays high.
Y tu abogado insiste que se quede callada.
Just please go slow.
yes, Your Honor. On March
El
10th,
10 de marzo
2025,
del 2025,
Officers were
Los
dispatched to
oficiales
Safer
fueron
Street
a
and
una calle Safer,
Seth Street en reference to
Seth
an
Street.
FSGI.
a una referencia de faltar y dar información.
The officers were
Los
advised that a white Charger
oficiales
left the scene
dijeron que un
following an
white Charger
accident
se fue de la escena después de un accidente
and was last seen
y
going
lo
southbound
vieron
on Shaver
y
Street.
en camino al sur en la calle Shaver.
The complainant stated
El
that she
quejante
was
dijo
traveling when
que
a
ella
white
estaba
Dodge
manejando
made a
cuando un
unsafe lane
Dodger
change
Cambió de carril, pero
Hey.
sí,
and collided with her.
y chocó contra ella.
The complainant
El
showed
quejante
officer a
dijo
picture of the
Él
suspect
tomó
vehicle,
una foto del vehículo y le enseñó
Which-
al oficial
showed the license
y le
plate
enseñó, tenía la
and
placa.
damage to the vehicle
y
on
el
the back
daño al
left
vehículo.
portion. The complainant
El
estimated that the
quejante
damage was
dijo que
around
él
$1,000.
está estimando que costó como $1,000 en reparación.
Officers ran the
Y los
vehicle and
oficiales
found the registered
Vieron la
owner to
placa
be
y
Juan Maneno.
encontraron que el dueño era Juan Veneno.
The officer located the vehicle at the apartment complex
Encontraron
where the
el
vehicle was
vehículo
registered
en
to.
los apartamentos a donde estaba registrado.
The officer met with
Y
Juan
el
and his
oficial
wife, who's
habló
the
con Juan y
defendant.
la esposa que la acusaron.
And just like that case dismissed no video, no eyewitness, no undeniable link. Even with the husband's admission, it wasn't enough. In court, gut feelings don't convict, evidence does. Would this outcome sit right with you if your car was the one left dented?
Juan advised the officers that the
Y Juan
defendant
le
had been
dijo
driving the
que la
vehicle all
acusada
day,
estaba manejando todo el día el vehículo.
and that the only damage to the vehicle should have been on the front bumper from a
Que tenía
previous
el
incident
vehículo
and
era
nothing
en la
else.
parte de frente de un accidente previo.
The defendant advised
El
officers
acusado
that she was
le
driving the
dijo
vehicle and had
ella
recently
estaba
gotten back from a Walmart,
El vehículo y había regresado
which is
de
around
Walmart
700
como
feet from where the incident
700
occurred.
pies de a donde ocurrió el
She denied hitting
incidente.
anybody.
Y ella negó pegarle a cualquier persona. Negó que
Your Honor, so based on the
y basado
information,
en la
the
información de ese.
car was registered to his wife.
So, how do we know
And
who's driving
the
it?
complaint,
¿Y
the
cómo sabe quién
Juan
está
stated
manejando?
that he was the one driving and she admitted to being in that location at the time.
Juan dice que-
She denied hitting, right? Do we have any kind of evidence that puts her at the scene that she's the one that causes the accident?
Que ella estaba ahí y causó el accidente. Go ahead.
That she was the one, within 700 feet of the accident and that she had access to the vehicle.
And just like that case dismissed. But let's unpack this. The husband said she was driving the car all day, but no video, no eyewitness ID at the scene, no slam dunk proof. It's a reminder, in court, maybes don't cut it. Would this outcome frustrate you if your car was hit? Tell us below.
Tenía acceso al vehículo y estaba a 700
And this
pies
vehicle was the one that was in the
del lugar.
accident.
Y ese fue el vehículo que estaba en el accidente.
And that wraps it up. From domestic violence with pregnancy involved to a brutal school assault and a hit-and-run dismissal, this court session had it all. What moment shocked you the most? Drop your reactions below, and remember, the courtroom isn't just about law, it's where lives pivot.
Did you say that the husband said that she was driving it?
She was driving
El
it all
esposo
day.
dijo que estaba manejando. Dice que sí.
Do you want to add anything? Did you want to say anything?
No,
Yeah,
two
yeah,
things,
yeah.
Judge. Number one, there was no evidence that
No
she
evidence.
was, as you mentioned, there was no evidence that she was
Yeah, yeah,
driving the vehicle. And just because she had the vehicle all day does not mean she
Dice
was
porque
driving
tenía
it.
el vehículo ese día.
For example, when
No
I'm sure my
significa
daughter's
que estaba
home,
manejando.
I'm sure,
Porque cuando
and she's using one of our vehicles, I'm sure that her lunkhead boyfriend is probably driving it the majority of the time. Additionally, this vehicle is insured. There's never been any report of anyone, but people had consent to drive it, driving it. That defense is not going to be erased, so this is an insured incident.
It's just,
un incidente
we got A, we got C, but you don't have B. I mean, I just don't think that,
A ver,
officer could have gone to Walmart, pull video, see her coming out, other
pueden ir a Walmart a ver si
cameras anywhere else. I don't know, but I just,
no hay
I
prueba.
don't think there's enough.
Okay.
You know?
Sure.
All right, I'm gonna find no probable cause in your case, man.
Va a encontrar que hay motivos fundados para mantener, pero
Please be careful when you're driving.
ten cuidado con
If you're going to drive, do not drive unless you have a valid license.
no